up and do his report. Please welcome Kyle, our Chief Legal Officer.
Good morning, everybody. Sakuze, Skyze, Denize, si Kyle Parker, Satne. Thank you for the introduction. I am the Chief Director of Legal Services with Carrier County Family Services. Our report is at pages 7 and 8 of the booklet that you received, if you wish to follow along. I can advise that this is our second year in existence, and in addition to providing the support services internally within CSFS, one of our most important functions at the moment is to also support jurisdiction. While the lawyers at Radcliffe are preparing our draft legislation, and Lincoln and his jurisdiction group are meeting with the communities and helping us move forward in that regard, our role right now is to prepare ourselves for the gradual transition of receiving the actual ministry files, and we're preparing to do so by readying our own database structure, our information gathering. So what we've done so far is collected approximately 100 files from the ministry, and we've begun actively working with the designated representatives and working with the families who are subject to those files. We have roughly 50 files that are presently active before the courts in a variety of stages. And we're doing much more than just cataloging. What we're doing is we're actually working through those files and determining what stage of proceedings those files are in. We're working with the lawyers who are attending mediation, and more importantly, we're beginning to attend court and do what we can to what I would characterize as break up the logjam. There are a number of trends that we are seeing as we work through these files, and I would characterize them as rather disturbing. They may not surprise you, and what I'd like to do is go through a few of these trends this morning and just share what we're observing as we are working through these files. And I respectfully suggest that this is what really reinforces the need to transition the files outside of the ministry's hands and begin moving those over to the communities who, again, I would suggest will be much better able to provide the services that are necessary in a much more timely fashion. So if we can just move on to the first slide. Oh, I have a clicker here? Oh, there we go. I'm responsible for the, back. Okay, so I don't want to get too into the details of the CFCSA and the specific provisions of it. Needless to say, once a family becomes involved with the ministry, there's a number of key steps that need to be taken, and two of those are the presentation hearing, and then you have a protection hearing. Now, the presentation hearing occurs within the first roughly a week of a family becoming involved with the ministry. And shortly thereafter, there's what's called a protection hearing. And that is a situation where the matter comes before a judge, and a judge actually determines, based on the evidence presented by the social worker and director's counsel, as to whether a child is actually in need of protection. Now, what's really important here is once it's determined that a child is in need of protection, there are specific timelines under the CFCSA by which the ministry has to make some very important determinations. They need to determine whether or not the children involved can be reunited with the parents, or whether there has to be a more permanent placement with an alternative caregiver. Now, when we're looking at the timelines involved here, specifically children under the age of 5 years of age, the director has 12 months to decide what it's going to do, whether the child's going to be reintegrated with his or her family, or whether or not it's going to be with an alternative caregiver. For children under 12, it's 18 months, and for children over 12, as you can see, it is 24 months. Now, what I'm finding disturbing in the files that we're looking at is these timelines are being grossly neglected. Specifically, we have children that were apprehended within days of birth. That should have been determined within 12 months. I was in court on September 5th dealing with the matter. The child, in fact, had been apprehended within days of birth. This was 5 years after the child had been apprehended. So 5 years this infant has been in the care of a caregiver. There was no chance that this child was going to be able to be reunited with her family. So a permanent plan needs to be made for this young child, and yet what happens is you find the director appearing in front of the courts and just getting extension after extension and after extension. And it does result in a considerable amount of prejudice to the child, to the caregiving family, because that family has to live under the scrutiny of the director, of social workers. They have social workers meeting with them periodically throughout the year to assess their families. The caregivers are not able to make medical decisions, they're not able to make educational decisions. So what you have is a very paternalistic and again, colonial approach to what we're seeing, how these families are being treated. And from what I can see, reviewing the file, there does not appear to be a real need for them to do so. And I'm not here to suggest or answer why, but again, this is the trend that we're seeing time and time again as we're going through these files. So as we move to jurisdiction, it really reinforces the need to get these files out of the ministry's hands, get these files out of contracted lawyers' hands, bring them back down to community so we can make timely decisions, and we can look at these truly through a contextualized, child-centered approach and make decisions that are in the best interests of the children and the families with whom they're residing. The next thing that I'm observing out of the files that we're evaluating is the failure of the director's part to inform children of their rights. The CFCSA, specifically the Child, Family, and Community Services Act, it has specific provision in it that enshrines children's rights. And it's a very long list. I've abbreviated some of it, but some of the rights that children in care have is to be consulted and express their views according to their abilities about significant decisions affecting them, to receive guidance and encouragement to maintain their cultural heritage, to privacy during discussions with members of their families, to privacy during discussions with a lawyer, the representative or a person employed or retained by the representative for the children and youth. And most importantly, what I would suggest, or one of the most important aspects of this, to actually be informed about and to be assisted in contacting the representative under the Representative for Child and Youth Act or the ombudsperson. And what we're seeing is a failure on the director's part to give children the opportunity to seek advice or to get information from somebody that is actually there to advocate on their behalf. There's been a number of files where I've raised this issue now, and it seems to be glossed over by the director and their counsel. It doesn't seem to be taken seriously. And again, as we move into our own jurisdiction, it's one of the places that we're going to have to really focus on is children have the right to be informed. They have participatory rights to be involved in these proceedings. And it may vary depending on the child's age and their maturity, but nonetheless, children are entitled to participate in any proceeding for which they're involved, and that's just not being respected at the moment. So one of our roles through the legal department is trying to push the director into providing this information to children to allow them to access advocacy services where appropriate. And again, along the lines of children's participation, the participatory rights of children are enshrined in the United Nations Convention on the Rights of the Child. And I'm not going to go into too great a detail on all those articles. It's a very substantial document setting out many, many rights of the child that are enshrined in international law. We are subject to that international law. Canada and the provinces have ratified that legislation, and as we move forward with our legislation, it will have the effect of federal law, and it will also have to conform with the articles as set out in the UNCRC. And again, when we look at Article 12 of the Convention, it specifically states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. Children are allowed to participate. And the question that I'd like to leave with you today is, to what extent do we allow them to participate? Right now, the courts are of the view that children should be insulated from these proceedings, and in particular, high conflict situations, family law matters, children should be insulated from that conflict, and I don't think any of us would disagree with that. But when we have protection proceedings for which children are involved, and they're effectively being left out of that process, the question becomes, where is the greater harm? Is it leaving them out of the proceedings completely and not giving them a voice, or is it more harmful including them? The method of including children right now in these proceedings is often taking the form of what we refer to as an ILA letter, independent legal advice. So effectively, a child is brought into a lawyer's office where they've never been before, sat down before a lawyer whom they have never met before, and that lawyer says, "What do you want? Where do you want to live?" And it's as simple as that. It's not a contextualized analysis. They aren't getting legal advice. These aren't people that the child is familiar with. They're not members of the community, and they're simply being asked, "What do you want?" And in response to that, the lawyer drafts up a letter, files it with the court, and that's what a judge relies on. It's a very narrow window into the proceeding and into that child's mind. I suggest that children deserve a lot better. They deserve that contextualized, child-centered approach. They may not need to be at the table with counsel, with social workers, but they definitely need to be involved and they need to be listened to. I've had many cases where children were adamant they wanted their voices heard. They were resolute in their decision-making, and there are so many roadblocks. One has to question whether or not that is actually making its way through to the decision makers that are making life-altering decisions for these children at often very, very important stages of their lives. So again, I'd love to hear from each and every one of you, if possible. What are your thoughts with respect to how we are going to include these children in the decisions that are being made on their behalf? Again, I think it's probably one of the most important decisions that we're going to have to try to reconcile as we move forward with our legislation. In addition to the work that we're doing with jurisdiction, I am also the privacy officer for CSFS. I'm working internally to assist the organization, make sure that it conforms to the privacy expectations under the provincial legislation. In the spring, we contracted Beverly Hooper, and she provided a privacy impact assessment, an organizational-wide impact assessment, considering the privacy measures that we've taken organizationally to comply with provincial legislation. I can advise, I've spoken with Warner about this, and what the legal department is proposing to do is organize we're going to organize Ms. Hooper to travel north here, and we're trying to organize 2 engagements for communities to specifically answer any questions, provide information about the privacy requirements that are going to be required or expected of communities to follow as we start working into this path towards jurisdiction. And again, I would love to hear from you with your questions, any sort of comments that you may have with respect to organizing that. It's still in its infancy. I've spoken with Ms. Hooper about it, and we're starting to make plans. But again, as far as location, timing, I would love to hear from those that may have input into those decisions so we can start organizing that in greater detail. And finally, the car raffle. For those of you that haven't bought tickets to the car raffle, please visit us at our table. Naomi's out there. We have a lovely vehicle that's been donated to us. With the relatively small amount of tickets that are being sold, you got a really good chance of winning. So that being said, if there's any questions, I'm happy to address them here and now, or you can find me at our table later on. Thank you so much, Natalia.